on Law Weekly, we look closely at the Court of Appeal judgment on the powers of the EFCC to prosecute 7 judicial officers where such individuals have not first been dismissed or retired by the National Judicial Council, the body saddled with the discipline of judges. We have the views of 2 senior advocates of Nigeria, Mr. Sowemimo and Mr. Norris Quakers. Also on the program, lawyers react yet again to the NGO bill, which seeks to provide for the establishment of non-governmental organizations regulatory commission for the supervision, coordination and monitoring of NGOs and civil society organizations, among others in Nigeria, and for related matters. Plus our weekly recap of the top trending stories from the courts. Hello and welcome to the program. I am Shola Shuyeli. It was on Monday, December 11, that the Court of Appeal sitting in Lagos struck out the charges filed against the Justice of the Federal High Court by Yelsa Division, Justice Ailadzira Ngajiwa, who is charged by the EFCC with collecting bribes to pervert the course of justice. In a judgment delivered by Justice Obaseki Adejumo, the court held, among other things, that the National Judicial Council, NJC, must first perform its constitutional role of disciplining a judge and recommending him for prosecution before the EFCC can file charges against such a person. Predictably, there has been no shortfall of reactions to this judgment. While some salute it as the correct position of the law, others say it seeks to confirm judicial immunity on judges and further give the impression that there are 2 sets of laws, one for the ordinary Nigerian and another for judicial officers. On the program today, we represent these 2 schools of thought. I'll begin with Mr. Norris Quakers, who applauds the appeal court judgment as the correct position of law.
This is actually the constitutional provision, and it's very apt and very clear. The National Judicial Council is vested with the power to recommend for removal and also the power to discipline. And the disciplinary power there is first to suspend pending when the president or the governor acts on their recommendation. Now, in relation to, and it's also not far-fetched, not too long ago, a particular judge in Kano conducted himself in a way that projected criminality, and a petition was done in that regard. The National Judicial Council investigated and recommended to the governor of Kano State not only should he be removed, and they went further in recommending that he be prosecuted.
That is after when they found out that there was some merit in the petition.
Certainly. Now, so you can see the way and manner the constitutional provision is couched. It is not as if judicial officers are immune from prosecution. One particular case that comes to my mind is the case of Gani Fahimi against IGP. Even the president, immunity is not absolute. It's also not in perpetuity. The court also interpreted Section 308 of the Constitution to the effect that when you want to claim immunity from prosecution, it does not bar a prosecutorial agency from investigating the allegation. If you want a particular judge to be removed for impropriety or for corrupt enrichment, and you have the facts, you kickstart the process by raising a petition to the National Judicial Council, which has the power to first look at what you have presented, call the judge. Once it is satisfied that the allegation is weighty, mind you, the National Judicial Council does not enjoy criminal jurisdiction, can only do this administratively. And the administrative inquiry is just to know the correctness or the truth or the validity of the allegation. Once it is satisfied, the judge will then be recommended, because whatever the judge does in the performance of a judicial function, he is still a subject of the National Judicial Council. So the National Judicial Council, by the Constitution, because we're looking at a constitutional provision, by the Constitution, the only body that is allowed or permitted to discipline him is National Judicial. Now, if the National Judicial Council does not make recommendation, what then happens? The National Judicial Council must make a recommendation for his removal in the performance of his judicial function. If he commits a murder, it is outside the scope of his duty. He will be arrested, he'll be tried. If he rapes, it's not in the performance of the judicial function.
If he rapes the party,
It's not in the performance of the judicial function. Rape is not recognized. It's not in the course of the judicial duty. That is not what is recognized. But it could be seen as conduct in breach of the judicial code of conduct. And then the National Judicial Council will sanction. And that's the way it works. So I do not see all this hue and cry, and then a number of us, a number of my colleagues, condemning the judgment of the Court of Appeal. It's a lucid judgment. It's sound. I've read it. You can't fault it.
So can we extend this argument further, like Mr. Falana says, that a professional in the private sector who is standing trial for corruption can rely on this judgment of the Court of Appeal and insist on going through the administrative procedure before they are subjected to trial? For instance, a medical doctor who is charged with murder in a state high court for killing a patient due to criminal negligence may challenge the case on the grounds that the Medical and Dental Practitioners Tribunal has not been given the opportunity to first determine the allegation of professional misconduct against him before being prosecuted.
It's not true. We're dealing with a constitutional provision. The National Judicial Council is seen as a federal executive body. Its independence and neutrality is also provided for in the Constitution. Its power to discipline is also provided for in the Constitution. The Nigerian Medical and Dental Association is not a creation of the Constitution. We're not looking at statute, we're looking at the Nigerian Constitution. And you're also looking at the judiciary. Now, if there's a provision in the Constitution that vests what you call disciplinary jurisdiction in the National Judicial Council, which is a constitutional provision, if you have not exhausted it, if you have not engaged it, if you have not deployed it, if you have not used it, you can't say otherwise. You also need to look at the composition of the National Judicial Council. Not all members of the National Judicial Council are lawyers. Therefore, you see a constitutional body that is vested with the power to ensure neutrality and independence. So if there's an allegation against a judicial officer that he has breached, mind you, there's also a judicial code of conduct. If a judge is found to have breached judicial code of conduct, the first thing that they do is recommend his removal. And over the years, that has always been the case. Some justices of the Court of Appeal have been removed. Some judges of the High Court have also been removed. And this is the first time that we're now seeing judicial officers standing criminal trial. It's not as if you cannot stand criminal trial. And it's not again about the individuals. It's about the institution. You cannot desecrate the institution. Let the man go. If you have found any judge of criminal culpability, any judge, and I mean any judge, let him first be removed. And then you can, because when you try a sitting judge and treat a sitting judge as a common criminal, if at the end of the day he's not found culpable, you have not only tarred him for life, you have not only scandalized him, what about members of his family? What about his friends? What about his associates?